have a view of the DSA now. Here, we're talking about intermediary services. So you have three different types of stakeholders: mere conduit services, catching services. Those are extremely technical, okay? They are subject to obligation, but merely they are storing their data or enabling transport of data. We have hosting services. Within that hosting services categories, there are two different types of stakeholders: mere hosting services or online platforms. Provider qualifies as a mere hosting service provider if the dissemination to the public is in a minor or purely ancillary feature or functionality, for example, the comment section in an online newspaper, or cloud computing services or web hosting services when serving has infrastructure, such as the underlying infrastructural and computing services of an internet-based application, website, or online platform. So if you have ancillary services or functionality, although you are mere hosting services, you can still qualify as hosting services. But the most important part here is online platform with two different types: social network, marketplace. So you can see, we talked about the DMA. Online platforms are subject to the DMA, but they are also subject to the DSA. Why is that? It's because, again, it depends on their dominant position on the market, significant role on the market, that they need to be regulated. There are some prohibition of gathering data, and then there are additional prohibition I would say, at a different level. And then you have the DGA that provide alternative to those business models. Because here, online platform, they make money with online advertising, with targeted advertising, because they are gathering that data, your data or everyone's data from different data sources. Those are, I would say, a first level, and then we have very large online platforms, VLOPs, or very large online search engine, VLOZEs. Okay, those are, because they have a higher or a larger dominant position on the market, they are, of course, subject to a larger number of obligations. And this is basically an overview of those obligations per categories of providers. In a sense, those obligations are not that different from what we have under the previous e-commerce directive. They just are stronger, I would say. On the liability side, for example, nothing really new. Regardless of whether you are a mere conduit service provider, a catching service provider, or a hosting service provider, you have an exemption for a liability, and there is no obligation for general monitoring. Meaning, in practice, I am a hosting service provider. Basically, I store your data, but I'm not allowed to access the content of that data. So I don't know what you have. Is it like a picture of my family? Is it like my financial statement? Is it like pedopornographic photos? That I don't know. The thing is, let's say I'm sharing online counterfeited product pictures, and I'm going to sell that from any C2C platform, and then you, as a user, and I want to buy a Louis Vuitton bag, and I have a look to that website, and I say, well, this is a counterfeited product that I'm going to wear. I'm going to warn the C2C platform service provider, and then that platform service provider is now allowed to act and to remove that information. Okay, this is very common under EU law, and this is not really new. What's new, so to speak, is that there is more like proactive obligation. So you need those platforms need to respond more quickly. They need to be more effective. They need to anticipate that with some kind of a traceability, KYC, risk assessment, to understand better who sells what online before. Is that someone that is legit or not? That would be determining. From a data angle, what would matter more is transparency. And as you can see, the transparency obligation are merely on the hosting services, and meaning, and more precisely, on online platforms, online market, and at the end, very large online platforms or very large online search engine. So there is a stronger transparency obligation on the term of condition, what is restricted, what is not. There is an annual transparency reporting obligation, but from a data angle, what would matter is everything that related to online advertising. Again, you're going on a website, you want to sell a product to another consumer. The question is how that platform analyzes your selling habits or your buying habits, how they combine that data with another type of information, and then they target you better. For example, I want to sell my car on a C2C platform. It's a fantastic information. Why is that? Because if you sell your car, it might be because you need another car. So you can sell that data to a car manufacturer or to a car dealers. And this is all about gathering that information. You have, for example, there has been studies on people looking at or just selling or buying kids or children equipment, like a children bed or so on, and they say, okay, they want to buy a 6 months a bed for a newborn, maybe because she's pregnant. If she's pregnant, we can sell her other type of services. So this is what we're talking about, and the type of granularity we're talking about online advertising. In terms of obligation, so here we have a focus on the online platforms and the very large online platform or very large online search engine. Let's say you are under, there is a threshold. If you are under 45 million monthly active recipients, then you have less obligation, merely a transparency, online advertising, recommendation, and so on. So it's all about the online advertising for each specific ads presented to the recipient, allow him or her to realize that the information display is an ad, identify the person and whose beyond the advertisement is presented, and identify the main parameters used. What we're talking about is that you need to understand that when you receive something that's an ad, who benefits from that ad, and how this ad somehow has been made to you with the main characteristic. It means that you need to understand if that data has been combined, you need to understand if that is targeted advertising, and so on. It goes pretty deep on the transparency, meaning that it's like you receive something, you need to understand how, why, and to what extent. Of course, if you are over the 45 million threshold, the number of obligation goes far higher. In terms of transparency, online ads, recommendation, and supervisory fee, but also in terms of risk assessment and compliance function, risk management and crisis response, audit, and data sharing. Okay, it is extremely burdensome. So as you can see, we have a limited number of very large actors with a very strong position on markets. When you are there, the number of obligation is just skyrocketing with the new EU digital package. And the purpose of that is that if they are so strong on the market, we don't want them to be stronger. We just want them to enable more data sharing so that we have smaller stakeholders getting into the market, because at the end, it's considered to be better for consumers and more cost effective and so on. And that is likely at the end to create more jobs and to create more opportunities for European organizations. Because who are we talking about? Google, Meta, Amazon, US. TikTok, Chinese. We don't want them to have that level of dominant position on the European market. This is the purpose of a lot of the new EU digital package, is to support European industries and European innovation on the market. So let's have a focus on online advertising shortly. As I said, it's all about transparency. So the level of transparency goes higher, either whether you're an online platform or a very large online platform or very large online search engine. As I said, the transparency obligation, it's all about identification, that's an ad, and how it became an ad, where did that come from. For a very large platform and very large online search engines, it goes a little higher in terms of obligation. There must be a repository, a registry of all those ads, content of the ad, person on whose behalf the ad is, the period during which the advertisement was presented, whether the advertisement was intended to be presented specifically to more particular groups. So there is to identify what is the purpose of the ad. Okay, you have a kind of repository that is accessible, and you say, oh, I remember that 2 months ago I received an ad and I didn't pay attention at that time of what is the type of ads and what is the purpose. And you can go there and you can check who was that, would that come from, and what is the purpose of this. The total number of recipients of the service reach and so on. But here, interestingly enough, there are also prohibition, very strict prohibition, and those are additional obligation to GDPR. First prohibition is prohibition of advertisement based on profiling using special categories of data. That could be health data, that could be personal data revealing racial or ethnic origin, political opinion, what we call sensitive data. Under GDPR, it is not prohibited. It is extremely regulated, but it's not prohibited. So interestingly enough, we have GDPR enabling or allowing reuse of that sensitive data for the purpose of profiling. It's regulated, but now when you are in an online platform, that is now based on the DSA completely prohibited. So it goes further. That it's valid for sensitive data and for profiling using personal data of minors, of children. So this is where we have an additional obligation here, and that applies to both online platforms and to very large online platforms. So this is very specific. And again, this is a kind of a cross approach to cross field, because we have both competition and both data converging to reach a highest level of protection. Now we're going to the AI Act. Basically, so the AI Act it's not a data privacy nor fundamental rights legislation, and I must say that it might be surprising at first sight. It's merely a product safety regulation, and that is, the approach is slightly different. But let's go and unpack into the concept that lies on the essence of the AI Act. So AI systems that are likely to fall within the scope of the AI Act are required 4 different prerequisites. It's a machine-based system designed to operate with a varying level of autonomy, that may exhibit adaptiveness after deployment, so meaning that it's evolving and it's self-learning mechanism. But what would matter here is the last, from a data angle, is the last prerequisite. All is a machine system, a machine-based system, and again, with level of autonomy that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as prediction, content, recommendation, or decision that could influence physical or virtual environments. And this is where there is an overlap, again, with data privacy. We are talking about almost automated decision-making process. And this, where if the AI is fed with personal data, then you have an output, and that output have consequences. On the same person was data fed the AI system, then there is an additional layer of complexity with GDPR. Of course, there are so large a variety of use cases where you got data that are not personal data. This is right. But in most situations, personal data would be very interesting for AI system, because this is where they can target, analyze, anticipate, predict better, I would say, situation. Then we have different other concept with general purpose AI, say AI model, including where such an AI model is trained with a large amount of data using self-supervision at scale, with two other requirements that display significant generality and is capable of competently performing a wide range of distinct tasks, regardless of the way the model is placed on the market, and that can be integrated into a variety of downstream systems or application, et cetera, et cetera. Here, we're merely talking about different layers, different situation, but at the end, we're talking about the same AI mechanism that apply, and that is likely to overlap with data privacy and with GDPR issues. What is the personal scope of the AI Act? You have very different stakeholders, product manufacturers, providers of AI system and general purpose AI, authorized representative of providers, importers of AI system, deployers of AI system, distributors of AI systems, so basically everyone that is related to AI. Again, we have a very inclusive regulation, and very much like the DMA and the DSA, anyone that going into that category is likely to be subject to a higher level of obligation, especially if they rely on AI, which a lot of those big tech company relies on AI now. So somehow there is no way to circumvent the EU digital package for the big tech company. That you go back to the DGA, for example. You know, I talked about the altruism and the data intermediation services. If a gatekeeper like Meta create an altruism organization, they could get data for free. That's not possible under the DGA. If they rely on the AI system, because on the AI Act, and they want to gather a lot of different data from a lot of different data sources, and they want to retarget, that would be extreme. Again, the purpose of the EU digital package is to regulate very strongly that are I would say, dominant position stakeholders so that they cannot reuse their data abusively on the other side. AI Act is likely to apply to Japanese companies as soon as they sell AI product or related services. Even they get data from AI system providers and deployers based in non-EU countries are covered by the AI Act if they market AI system product in the Union or they provide the result produced by the AI system is used in the Union as well. So if you are from overseas, from Japan or for the US, doesn't matter. If you sell your product on European, in the EU, you're likely to fall within the scope of AI, and the AI Act, sorry. The risk-based approach. So on that, it is very much like GDPR. You have something that is completely unacceptable that's related to any discrimination mechanism. It applies to public monitoring and so on. That is likely to fall within the first category. But then you have, I would say, the large variety is it's high risk. What is high risk? Let's say that I'm going to rely on AI for recruiting employees. I receive 100,000 CV. I just want to select them. How I would rely on the AI system, it's likely to fall within the scope of the high risk category. Then you have, if you are outside the high risk, you have minimal risk. So it's basically common law. You have certification, for example, CE marking, et cetera, et cetera. And for very specific systems, let's say chatbots, then there are specific transparency risk and then obligation. It's somehow independent either from a high risk or minimal risk. It's just because you have a specific purpose. And that specific transparency risk is likely to apply to general purpose AI models as well. So here it's all about transparency. It's just to make it clear that you are interfacing with an AI system and not with an individual. Again, transparency is key for consumers or for any individual or for any organization. Who I'm in touch with, who is my the organization and the individual I'm talking to. You need to understand that how they are using your data and for what purpose. We have that in the DSA. We have that in the AI Act as well. That would be, again, determining. How to comply with the AI Act in practice. So very shortly, we have 4 different steps. The mapping the systems, map the system develop and use, identify whether those systems are covered by sector regulation. That would be determining. this is very much like GDPR and data privacy. You need to, there's a mapping exercise, and that would be the same under the data hack I'm going to talk to right after. Step 2, identifying the scope. Determine whether the system models identified fall within the material scope of the AI Act, and especially whether the AI systems model fall within the definition of AI system models and under the AI Act. I talked about the self-autonomy criteria. So, for example, we have a lot of clients say, oh, what I sell is AI. And then what we did is that we dig into their AI or so-called AI system. But it's not like AI within the meaning of the AI Act. It's because it's not self-learning. It does not infer or it does not predict neither. So it's not likely to fall within that category. So we're talking of probably it was more limited, I would say, AI system that we think, at least at first sight. There is the territorial scope of application, as I said, and determining whether stakeholders involved fall within the scope of personal application of the AI Act and identify the relevant qualification. Step 3 is classification of the AI system models identified. Step 4 is allocation of implementation in the light of classification. But, sorry. Here. As I said, there is a strong overlap between the AI Act and GDPR. So as soon as the data that fed the AI system is personal data. Here, you need to have in mind that the concept of personal data is extremely inclusive under GDPR. Meaning that, let's say I have IP addresses. IP addresses, it's a series of different numbers for IPv4 system between 0 and 2055. So let's say I have an IP address that is 142, full stop 142, full stop 142, full stop 142. At first sight, this is not personal data because it's just a number, and that number, it's the number of a product that could be this, because I'm going online with my terminal, but the thing is that I'm the owner of that terminal. Well, let's say that this is a corporate equipment, but at least I'm the identified user of that terminal. So ultimately, this is personal data. So again, let's say that you have an AI system fed with product data, but that product data can be related to an owner or to an individual at some point. That is likely to be personal data. So you would have an additional layer of complexity because you have the AI Act and then you have GDPR that applies at the same time. And I would say here, this is where GDPR and the AI Act are extremely congruent because we have a very specific regime under GDPR called the automated decision mechanism, and then you have specific obligation under that category. It would apply to the data source. That would be personal data, GDPR apply, AI Act apply, because that the data source feeds an AI system, self-autonomy, and so on. When the AI is fed by that, just receiving or collecting the data, there is a processing activity under GDPR. So you have highly identifiable data, just collect by an AI system. GDPR is likely to apply. The question is, for what purpose? Is that for profiling? Is that for analytic purposes? Again, GDPR will apply. And then there is an additional level of requirements depending on the outcome. And the outcome, again, is a determining factor for falling into the scope of the AI Act. So you have the automated decision regime. What happened in that situation? Would you give your consent for this automated decision? Would you object to the automated decision? Let's say that I apply for a credit at a bank, and that bank rely on the AI, on an AI system. Okay, I fill a form to apply for that credit. So I give my revenue. I've got revenue for my business, but I also have financial investment, etc., etc. But the thing is, what they can do is that they can go online with Facebook. So I don't know if you know that, but Facebook has a scoring system to determine how reliable you are for paying back your loan, depending on your friends on Facebook, because it will determine who is rich enough or not. So typically, if that's not regulated or it regulated enough, then you can have banks analyzing your data from I would say, a pretty financial-centric, unusual banking analysis, plus analysis from a social network. But still, at the end, you have a score. And that score said, no, you don't get that credit. This is automated decision in the application of the European Court of Justice case law. What could you do then? You have rights. You say, okay, I'm objecting to that. And then you have the right to be heard by an individual. This is where, you know, how AI Act and GDPR are extremely congruent, because that would regulate either the way data is collected and processed by the AI system and the implication of that AI system on your situation, because that AI system was fed with personal data. Here is a focus on the FRA, what we call the Fundamental Rights Impact Assessment, versus the DPIA, the Data Privacy Assessment. When you have a look to the AI Act, at first sight, you can very strongly believe that actually both assessments are pretty the same. Because they're all assessment on fundamental rights, and ultimately DPIA, data privacy assessment, it's still related to fundamental rights. But the thing is that under the AI Act, this FRA only applied to high-risk AI system. The content of the FRA is true. It's very similar to GDPR, DPIA, to the extent that it focuses on the risk of harm for natural person because the AI system and the mitigation measures taken. So to what it applied? It applied to deployers only that are a body governed by public law deploying. That's all risk of AI system, essentially for public authorities. But that applies for the same for private entities providing public services. So it's very public-centric. Again, with the public utilities that would be at risk. And any other entity that deploy a system, and that would be credit, health insurance, for example, life and health insurance are likely to fall within that category. Enforcement, if you do not comply, is slightly higher than under GDPR. It can go up to 35 million or 7% of the annual turnover in case of direct violation of prohibition of AI for unacceptable risk. And it goes slightly under if you are just non-compliant with other obligation or incorrect or incomplete misleading information. It still goes under that 35 million, go to 15 million first and 7.5 million after 1%.